Hello folks, welcome to Legacy IAS Academy. In this video, we will be discussing a current affair topic. This video is presented to you by your faculty, Sushma KP. So what is the topic that we will be looking into today? How do habitual offender laws discriminate? This is a very important topic, and the possibility of this question coming in different forms, be it in prelims, mains, or interviews, higher because just this year alone, this has come into news 3 times. So we will go through this topic, the history, the present, the polity, what the judiciary feels about it. So we will be going about this topic in a very holistic manner, so do not miss this topic. Watch up until the end. Look at this. How are habitual offenders deemed so? What is the history behind denotified and nomadic tribes being seen as criminal tribes? Why are states like Gujarat not keen to repeal the habitual offenders laws? All of these questions we will be answering throughout the video. Okay. Before we enter further, we have an announcement from Legacy IAS Academy, wherein our new batch is starting for your UPSC IAS preparations. One advantage of your Legacy IAS Academy that is very lucrative and it offers this advantage and edge over others is that it is a limited 40-member batch. It is made sure that individual attention is given, LRP training is given. Similarly, your prelims mock test is given, all India mock test, mains answer writing, content writing, as well as preparing you for mains, as well as for your interview. Mock interview panels are present. So you will get a good amount of wide coverage, individual personalized attention. At the same point of time, we will make sure that you will be hassle free, that you do not need any other assistance in your UPSC preparation apart from your Legacy IAS Academy. So do check that out. For any further queries, you can contact the number that is given below. And our batches are starting on your April 17, 2025. We have one regular batch. We have one weekend batch starting on April 19, 2025. We also have a regular batch that is starting on May 12th. So the seats are filling up fast. Get through. Okay, we have also started, for those of you who are appearing for your prelims 2025, your free all India prelims mock test. Take advantage of this and make sure you're on par for your prelims preparations. All right, now let's get back to the video. As usual, I'll tell it to you like a story. You listen to it like a story. Habitual offenders. Presently, 14 states and union territories are having this concept of habitual offenders. Who or what is called as this? Habitual offenders. First, I'll give you the gist like a skeleton, then we will fill it up with facts. This concept of habitual offenders is a British colonial law. Meaning what? See, your British are very much known for your racial discrimination, racial segregation. They would do anything for the betterment of themselves, divide and rule, that, this, carrot stick, every possible policy which is detrimental to humankind and human rights that you have to know, they have all bought in it. Yeah. So, one such thing was your habitual offenders, wherein as initially the last laws they were implementing, the first set of it was someone who is prone to commit a crime again and again. Just the name wise, look at this: habitual offender. Someone commits a crime again and again and again, so he will be called a habitual offender, just by the simple generic example name of it. Now what happened to your British, that is in your colonial period of time, was they started creating additional, see, your British prides itself on being following your rule of law, okay, and also your natural rights. So they pride themselves on being civilized. They called India as a barbaric country. And yet the principles of justice, even what they applied to Indians, was so discriminatory that this was not applicable to us. Well, how do I tell that? For example, your magistrates were given additional power where they could charge individuals just on suspicion alone. That person could not even have committed a crime. But because he belongs to a particular tribe, who, in that, some people might have committed offenses, just because this particular person belongs to the same tribe, he will also be put under this tag of habitual offenders or criminal tribe. So it is more like any child who is born into that particular tribe will be automatically labeled it he is born into a criminal tribe. So now the magistrates had the power to punish them just on the suspicion alone, and not even the fact that they've committed a crime. Don't you think this is entirely discriminatory to the humankind? Leave ahead caste, that, this, everything, but don't you think it is discriminatory to your human rights itself? After independence, we know all these are colonial laws, many things we have to change. Yes, they did bring some changes to this habitual offenders, and they bought it with different names. But if you see, the name has gone, but the practice has still remained to continue. For example, the Chief Justice of India, D.Y. Chandrachud, has held that in prisons, even today, the manuals as to how which, like let's say, inmate is supposed to do which work. Usually, a person coming from your denotified tribe, that is your allegedly previous habitual offenders, they were the ones who were given the task of cleaning the bathrooms, manual scavenging works. Now, our articles, fundamental rights, constitution, everything speaks about human right, human dignity. Article 15 of 1 speaks about no discrimination. But don't you think this is a form of discrimination, especially on the basis of your caste? It's our fundamental rights in Indian constitution speaks about prohibition against untouchability. We shouldn't practice untouchability. Don't you think that these people are made to do a particular thing because they do not have a choice, and because they're coming from a lower tribes, according to them? And don't you think Article 23 is you cannot forcefully employ someone into a labor, that is your forceful labor, begar, etc. Don't you think here they are made to do the same thing? So when this, in your namesake, it has been changed to your denotified tribes, etc. But if you see in principle, just in theory, it's been changed, but in principle, it is continuing even today in your jails. So this was brought into the attention of your Chief Justice of D.Y. Chandrachud, or a three-bench judge. They sat and they held and they asked the union government, what is your take on this? Why are you not repealing this? Do you actually need this? And at the same point of time, see, it hasn't ordered, it has asked, do you actually need this? What is the issue with this? For that, your union government has replied telling that, see, there are many states, as much as your 14 states and union territories are still continuing that. Whereas certain states, when you go asking, let's say your Uttar Pradesh, they said, whatever that we need to be covered, we already have something called as Gundas Act. It is already covered in that. So if you're going to repeal this law, it doesn't matter to us, you can go ahead and repeal. Then when states like Goa is asked, you still have this, no? Why are you not repealing it? Goa said, see, we actually do not have this thing called as denotified tribes and all. So it doesn't matter that if we are going to do it or not, we either way are not doing. So us having this law is not affecting anything. Let this law be. For example, in states like Gujarat, they are telling we will not use this law for harassing anyone or singling out anyone. So let this law be on its own. For example, Delhi pay almost 25% of their convicts are all brought in under this act laws only. Then your Punjab told that, see, in the last 5 years we have not registered any cases against this particular law, and also we do not maintain a registry. One main thing about this habitual offenders is maintaining a registry. Constantly you will mention how this crime was committed. Let's say some other crime of that nature happens to that particular place, then this particular section or tribe will be the first person to be questioned. So your Andhra Pradesh government also told that we do not maintain such registries and we are not registered any case in the last 5 years. So it doesn't matter to us. You can go ahead and repeal it. So the states are now divided on this. This is the answer that your union government has given. Now we have to further watch and see as to what is the course of this law. Okay, look at this. Central state prison manuals. Laws must be revised within 3 months. Rules 3 judge bench headed by Chief Justice of India Divachan showed even 21st century regulations discriminate against scavenger class or habitual offenders. Now, for example, you have something called as prison manual, wherein you will have rules as to how which inmate you will treat how. You see, murderers, rapists, etc., all will be put together, but they will be given work such as your cooking, okay, washing utensils. But these people, because they are from this particular tribe, they are forcibly, because they're from the lower tribe, forcibly given things such as your sanitation only. Now, do you think this is right with regard to your human right discrimination? Look at this. The bench says everyone is born equal and cannot suffer lifelong due to the stigma attached to their case, a stigma attached to their caste. Okay, so this concept of habitual offenders, even though we may say it is colonial law, we have removed it, we have changed the name, we have changed the name, but we have not changed the practice. Many prisons, especially a Palangotan prison in Tamil Nadu, they segregated the inmates based on the caste. So these kind of things will raise eyebrows. Look at this. Article 15 of 1 is a basic fundamental right against discrimination, especially on grounds such as your caste. But if the state itself discriminates against a citizen, then this is the discrimination of the highest form. After all, the state is expected to prevent discrimination and not perpetuate it. That is, it has to reduce the discrimination and not increase it. Look at this. No prison authority enjoys amnesty for unconstitutionality. They are following this manuals of your prison, but the way it is followed is in one way or the other violative of Article 15, violative of Article 17, violative of Article 23. So, which in turn is what? When you're tagging someone as a born criminal, you are violating their basic right of Article 21. Don't you think so? Right to life. So these sections are also called as scavenger class. Look at this. No social group is born as a scavenger class. They are forced to undertake certain jobs that are considered menial and polluting based on the notions of birth-based purity and pollution. Whatever we have discussing, the sad thing is these are the issues that we've been discussing from the starting of times. From a Vedic period onwards, we've been discussing these topics, and we are in 21st century, and still we are discussing about these topics only. Your union government has come up with your two important laws on this, wherein it says Modern Prison Manual of 2016 and Model Prisons and Correctional Services Act of 2023, where both of them contain manuals as to how to treat the prison inmates, what kind of works to be assigned, and even in those, they have given these section or this kind of jobs which are, that is works which are divided among different sections of people. States like Gujarat want to continue it, telling they will not be harassing or they will not be singling out, they will not be discriminatory. States like Punjab are in the process of removing, that is, repealing these kind of laws. States like Haryana have completely removed it. The states like Uttar Pradesh are telling that they can repeal it, there is not an issue for them. Now we will see where is this origin of habitual offender actually begin in India. First and foremost, we will know about the origin of official your habitual offender from your National Commission for Denotified Nomadic and Semi-Nomadic Tribes, which was headed by Bhikkhu Ramji. Now, I would suggest you to remember these names because of the commission, what commission they were associated with. Prelims pay, it is very important. Better write this down. Okay, and like I told you in the beginning of the video itself, this has come thrice in the newspaper, wherein the committee goes on to tell that the origin of your habitual offenders can be traced to your British colonial law, wherein your regulation of 1793 gave summary powers to the magistrate. Summary powers to the magistrate means what? Any person can be punished just on your suspicion alone. And also, this did not just put a individual, but the entire tribe was put into that. Understanding? Entire section or chunk of people who have committed the crime, they put the entire tribe into that category. So this was the first place where this concept of punishing a person even for a not crime committed, but a possibility that these people only will commit the crime, so the concept of registry also started. Then from there on, it evolved into your Indian Penal Code of 1860, in your Criminal Procedure Code of 1861, where they started maintaining a registry. For the first time, they started maintaining a registry of dacoits and thugs, wherein they started writing out this crimes this person was committing. So this person is from this particular caste. Even in your present modern day manuals of prison registry, also you have caste next to the person. Then this got accentuated in your Criminal Tribes Act of 1871, where for the first time they introduced the terminology of criminal tribes. Certain tribes were given or attested the tag of criminal. They were of criminal nature, which means any child born into that particular tribe will now be labeled as born criminal, which means always they will be looked into suspicion that this particular tribe will do this crime only, and so on, so to an extent that they've held that this tribe will only do this crime only. They have no other job, and they have affinity towards crime, they have anti-social behavior. These were all the associations and tags that were put with that particular tribes. Okay, and in 1924 this particular law was made applicable throughout your British India, which means it was applicable to all the tribes everywhere in British India. This was your colonial law. After independence, after India got independence, a Criminal Tribes Act Inquiry Committee was set up. According to its report, again 1952, based on the report, Government of India repealed all criminal tribes laws across the country, and these committees, that is the communities which were under this particular habitual offenders or your criminal tribes, were now to be called as denotified, nomadic, and semi nomadic tribes. Understanding what did I tell? The criminal tribes, that concept was repealed, and to its place it was called as denotified, nomadic, and semi nomadic tribes. From the beginning of the video, like I told, the theory is removed, but the practice is continued. Further committees that was set up especially for the denotified tribes was your Lokur committee in 1965, which said that these committees had an anti-social heritage, they had affinity for crime. So this was somewhere on lines with your colonial time laws. Then after something changed, when the committees themselves were feeling like this even after independence, then what changed? That was this particular incident, custodial death of Budan Sabar. See, this particular person was found hanging in his prison cell. He was from a denotified tribe. A lot of police excess was used on him, which led to lot of people and a nationwide outcry as to why the people of denotified tribe are to be suffering like this. Do they not have their basic human right? Should they always be looked into suspicion because they are born into a particular tribe which may or may not have committed crimes in the past? Do they have no other choice to do just those crimes and no other occupation? Will they always have to carry that burden on their back? For that, Denotified and Nomadic Tribes Rights Action Group was set up, wherein they wrote to your UN General Assembly. They even wrote to your National Human Rights Commission stating that the plight of these members are too hard to be overlooked. Based on which your National Human Rights Committee formed an advisory group in the year 2000 and said that habitual offenders laws can be repealed. Now, when your NHRC told this, you have to also understand one thing. Yes, they have gone through a lot of things, seen, analyzed, and then they've told, but one of the issues is their decisions are not binding on the government. On the same line, your United Nations Committee on the Elimination of Racial Discrimination also saw how this habitual offenders or your denotified tribes were treated and on what basis they were booked. They held that this kind of laws should be repealed. So post this, that is post 2000 onwards, especially after the custodial death, the majority committees are of the consensus that this particular law has to be repealed as it is violative of their basic human rights. In 2008, your National Commission on DNT, that is your denotified tribes, semi-nomadic tribes, and nomadic tribes, which were headed by B.S. Serenke. Again, this committee person name and what for you have to remember, as well as your high level committee on tribal affairs minister headed by Professor Virginia Zagza. This also held that this particular laws should be repealed. These are not good for the people in any form belonging to your denotified tribes. According to your National Crime Records Bureau, 1.9% of India's 1.29 lakh convicts are charged under your DNT, that is denotified tribes. The highest is in your Delhi, where of all the inmates, 21.5% of the inmates are under this only, your denotified tribes. Okay, this is what your judiciary has told and asked your union government to take action on. What action union government is to take, we will have to watch and see. All right. At the end, we have a small information from your Legacy IAS Academy, where they have started prelims current affair compilation for your 2025, whoever are taking prelims. Specifically prelims oriented content current affair compilation is present. The link for all of this will be provided in the description box below. Do check that out. For anyone who is interested in learning mains answer writing, how to write an answer, how to set up content for it, etc., Legacy IAS Academy has launched Impact 2025 exclusively for your mains answer writing. Now, do check that out. If you like our content, subscribe to our channel, hit the like button, and share it along with your friends. Thank you.